Aaron.
Here.
Why didn't you say it the first time I said Aaron?
Because it's pronounced Aaron?
You done messed up, Aaron!
Aaron is here. Welcome back, everybody, for more SPTV, where every day's a great day not to be in a cult. Okay, there is a ruling that has been made. I'm a little late on this. This ruling was actually last month, but it just came to my attention recently. A ruling that was made in a lawsuit against the NFL regarding the enforceability of NFL's arbitration agreements that its coaches and I'm sure all of its other staff sign. And a court has ruled that NFL's arbitration agreements are null and void because of how unbelievably lopsided and unfair the arbitration proceeding is, because NFL Commissioner Roger Goodell, sorry guys, sorry NFL fans, oversees the arbitration proceedings, and therefore it cannot possibly be fair. This should have a huge impact in Scientology lawsuits and the enforceability of Scientology's arbitration agreements. Let's review what the ruling is, and let's look at the arguments for why this either would or would not impact the enforceability of Scientology's own arbitration agreements. This is fascinating legal stuff that I do not even vaguely claim to be an expert in, but it's just so important and relevant to Scientology litigation and the type of Scientology litigation that will be what brings down Scientology. I believe the civil litigation is what's going to pave the way and open the doors to the criminal prosecutions. It shouldn't be that way, but I believe it is that way. So let's just take a look at what we're talking about here. This is a case, Flores versus New York Football Giants et al. Brian Flores' case will not be compelled to arbitration. Again, this is from back in August, but it reads, today in Brian Flores' ongoing discrimination case against the NFL, the U.S. Court of Appeals for the Second Circuit affirmed the district court's order denying the NFL's motion to compel arbitration of his claims against the league and several teams. The court held that the arbitration provision of the NFL Constitution, dictating that the NFL's commissioner would be the arbitrator, is unenforceable for failing to meet basic and fundamental norms of fairness. The court applied a legal principle known as the effective vindication doctrine, finding that the NFL's arbitration terms are so lopsided and unfair that Mr. Flores would not have any legitimate ability to vindicate his anti-discrimination rights in the NFL's arbitration forum. They link to the full decision. For more details on the complaint filed by Wigder LLP on behalf of Brian Flores, please see here. Okay, quote, the significance of the Second Circuit's decision cannot be overstated. For too long, the NFL has relied on a fundamentally biased and unfair arbitration process, even in cases involving serious claims of discrimination. This ruling sends a clear message. That practice must end. This is a victory not only for NFL employees, but for workers across the country and for anyone who believes in transparency, accountability, and justice. Okay, I want to quickly jump over to an ESPN article about this just to see if it has any additional helpful language before I jump over to bridging it to the Scientology, the realm of Scientology. Okay, the NFL can, well, let's see. Court agrees Brian Flores' suit versus NFL. 3 teams can go to trial. The NFL can be put on trial over civil claims. Over civil claims that Brian Flores and other black coaches face discrimination. A federal appeals court ruled Thursday, finding insurmountable flaws with a league arbitration process that would permit Commissioner Roger Goodell to serve as arbitrator. In a decision written by Circuit Judge Jose A. Cabranes, I don't know. The appeals court said the NFL's rules forcing Flores to submit his claims to arbitration before Goodell do not have the protection of the Federal Arbitration Act because they provide for arbitration in name only. The Second Circuit said the NFL Constitution's arbitration provision contractually provides for no independent arbitral forum, no bilateral dispute resolution, and no procedure. Instead, it offends basic presumptions of our arbitration jurisprudence by forcing claims to be decided by the NFL's principal executive officer. The significance of the Second Circuit's decision cannot be overstated. Okay, good. That's just re-quoting the lawyer representing Brian Flores. All right. Okay, it gets into the subject of the claims regarding the lawsuit itself, which is not particularly relevant to the Scientology issue. Okay, good. So we have some particular language here that has been used. I'm going to jump back over to the first article and cite the language there. It uses a particular phrase here: effective vindication doctrine. Let me make a little note here. I'm going to make a little note for myself here for follow-up, okay? Because I'm going to do more than one video on this. We have the effective vindication doctrine. Okay, I'm going to do some follow-up on that. And then fundamental norms of fairness. I'm not sure if that's a legal phrase, but I'm going to write it down anyway. Fundamental norms of fairness. Fine. Okay, and then we're going to jump back over to the ESPN article. Okay. They provide for arbitration in name only. No, that's not what I'm looking for. Basic presumptions of it offends basic presumptions. No, that's not a phrase I'm looking for. That's fine. Okay, you guys get the idea. You guys get the idea. Saying it is fundamentally impossible for this process to be fair and unbiased, given the structure that NFL's contracts relating and their arbitration clause dictated. Okay, makes sense, right? Okay, so I asked Grok, and guys, I know you can't rely on AI to be all things that you want at all times, but it's much smarter than me. And I just want you to know what Grok had to say about this, okay? So I asked Grok, okay? Well, because first I asked Grok, okay, yes, what's the deal with this lawsuit? And it says the court found that the NFL's arbitration provision, which required disputes to be resolved by NFL Commissioner Roger Goodell, unenforceable under the Federal Arbitration Act. It was deemed unfair because Goodell, as an NFL employee, could not be considered an impartial arbitrator. Sounds familiar, especially in a case alleging league-wide discriminatory practices. As a result, Flores' claims can proceed in federal court, allowing for a public judicial process rather than a private NFL-controlled arbitration. So I asked Grok the next obvious question. Given this ruling, how can Scientology's internal arbitration be legal when it requires arbitrators to be Scientologists in good standing, and the person receiving or undergoing the arbitration is an ex-Scientologist, and Scientology internal policy prohibits Scientologists from finding in favor of ex-Scientologists? Now, I asked the question that way. Let's also consider that in the NFL situation, it's saying that Roger Goodell, as basically the CEO of the NFL, is incapable of unbiasedly presiding over an issue being raised, especially one that concerns discrimination throughout the entire NFL. In Scientology, not only do you have the problem of their arbitration contracts dictating that the arbitrators on the panel, serving on the panel, have to be Scientologists in good standing, but the convening authority of the arbitration is Scientology's internal IJC, International Justice Chief. So he's essentially the top, he's essentially the Chief Justice of the Supreme Court in Scientology is sort of the analogy that you would make there, okay? So he is to Scientology justice what Roger Goodell is to the NFL. Okay, so the answers from Grok are not good news when it comes to whether this ruling is going to impact Scientology. And it really sort of comes down to this religious protection that is enjoyed by Scientology because the IRS granted it tax-exempt status. And I do want to point out, though, that really the information that I'm sharing here is just kind of for the purpose of the debate and the discussion of this subject. In the Bixler lawsuit against David Miscavige and Scientology, there is a preliminary ruling pending by the judge, the previous judge, but it is, fingers crossed, about to be upheld by the new judge, that Scientology's arbitration contracts are unenforceable because they are unconscionable. So even though I'm about to read you some responses from Grok that may not sound very optimistic, as far as, the relevance of this ruling to Scientology. We really, truly are on the verge of, for the first time ever, getting a judicial ruling that Scientology arbitration contracts are unenforceable, not because they don't apply to the given lawsuit, but because they are, in fact, unconscionable. So that's a piece of good news. Let's see what Grok had to say about this. It says the Flores versus NFL ruling, Second Circuit, August 14th, 2025, is a narrow decision that invalidates a specific arbitration scheme because it allows the NFL commissioner, as the principal executive officer of the league and party to the dispute, to unilaterally control the process, rendering it arbitration in name only and outside the protections of the Federal Arbitration Act. The court emphasized that this setup lacks basic independence and neutrality required by arbitration jurisprudence, especially for, and it goes on to NFL-related stuff. However, it does not broadly prohibit all biased or internally controlled arbitration. Courts have historically enforced such processes in other contexts, including religious ones, with post-arbitration challenges available for evident bias. Scientology's internal arbitration system, requiring arbitrators to be Scientologists in good standing with the Mother Church and operating under church doctrines that label ex-members suppressive persons and prohibiting communication and implying bias against them, presents a comparable issue of inherent partiality. Yet its legality stems from distinct legal frameworks, particularly the First Amendment's protections for religious organizations, which courts have interpreted to limit judicial interference in ecclesiastical matters. Here's a breakdown of why it remains enforceable in many cases, despite parallels to Flores. 1, First Amendment protections for religious autonomy. Under the free exercise and establishment clauses, courts are barred from adjudicating or interpreting internal religious doctrines, rules, or governance. Okay, so how this has tended to, up until now, impact Scientology litigation is that Scientology is allowed to go to the courts and demand that the courts enforce Scientology's contracts. But the courts are not allowed to interpret Scientology policy to decide whether those contracts are fair. And this is so crazy that this is how these issues have played out in court so far. And this is why it is so exciting that we are on the verge of very likely getting a ruling in the Bixler lawsuit that Scientology's arbitration contracts are unenforceable because they are unconscionable. It is the first time that ruling will have ever been made in a court of law. Okay, so that's right. Courts are barred from adjudicating or interpreting internal religious doctrines, rules, or governance. It says this includes evaluating whether Scientology's arbitrative requirements or policies against ex-members create unfair bias. To rule on such bias, the court would need to analyze Scientology's teachings. For example, whether suppressive persons are truly barred from fair hearings, which is constitutionally forbidden. When something is so impossible to wrap your mind around, I certainly tend to feel it can't possibly be true. It can't possibly be true that courts can be relied upon to enforce Scientology's contracts while at the same time being prohibited from understanding Scientology's policies on suppressive persons to determine whether the contracts meet the legal standard required from the federal, the federal arbitration, whatever, that I've already read like a few times. Like, it seems impossible, which is why I'm optimistic the ruling will eventually come down that you're right. It is impossible. It's bullshit. It's bullshit. It's been bullshit all along. And it's not going to, this courts aren't going to stand for it anymore. I tend to be very optimistic on these issues, guys. You know me. Okay. It's going to cite a key precedent from the Garcia lawsuit. Key precedent, Garcia versus Church of Scientology, 11th Circuit, 2021, affirmed 2022. Ex-members challenged arbitration as unconscionable due to doctrines prohibiting good standing Scientologists from associating with suppressives like them. The court enforced the arbitration agreement, stating that assessing the claim would require an analysis and interpretation of Scientology doctrine violating the First Amendment. The arbitration proceeded with Scientology selected arbitrators and awarded only partial refunds, and the outcome was upheld. This contrasts with Flores, where the bias stemmed from a secular employment contract under the NFL Constitution, not religious doctrine. No First Amendment shield applies to the NFL, allowing the courts to scrutinize Goodell's role directly. There you go. It goes on and on and on. I don't think for our purposes, there's no reason to delve into this any deeper. It comes down to religious versus non-religious. And this is why, even more so than the financial implications, this is why it was so important for Scientology when it got its tax-exempt status back in 1993. Scientology in the early days had tax-exempt status, and then it lost it because the IRS determined that L. Ron Hubbard was personally enriching himself from the monies of Scientology. They stripped Scientology of its tax-exempt status. In 1993, Scientology managed to get its tax-exempt status back by filing over 2,000 lawsuits against individual IRS agents, bringing the IRS to its knees. David Miscavige, Marty Rathbun, and some others walked into the IRS offices and demanded a meeting with the IRS commissioner. They did not get that meeting right then and there, but it started the wheels in motion. And according to Marty Rathbun, when they did finally meet with the IRS commissioner, he asked straight up, "Can you guys really, if we do this for you guys, can you guys really stop the pain, turn off the spigot on all these lawsuits? Can you guys really get rid of these lawsuits?" And Marty replied something like a switch or like a faucet. And so it really was. I mean, honestly, I'm not aware of any other organization other than Scientology that was basically able to pressure and harass and bully the IRS and bring them to its knees. And the result was not just David Miscavige being able to amass a giant, cash hoard, but it really was preventing Scientologists from ever being able to get justice in a court of law against Scientology. So fingers crossed, guys. It's really, it could be weeks, could be as short as weeks, it could be as long as months. In the Bixler lawsuit, Bixler versus David Miscavige, Scientology et al. Preliminary ruling was already made. Arbitration contracts unenforceable because they're unconscionable. Scientology saw the preliminary ruling, showed up to the hearing, and said, "We want a new judge." They had one "we get a new judge" free card to play. That was about a year ago. And Scientology has been doing everything it can to drag its feet and try to delay and try to even avoid having the new judge issue the preliminary ruling of the previous judge. But I think we're going to get it soon. And we'll see, guys. I mean, when I see a ruling like this in the NFL, you go, there's no way that ruling could be made for the NFL, and the similar ruling couldn't be made for Scientology. We'll see, guys. We'll see. Okay, let's look at some starred comments, and we'll wrap this one up. Brian Lucas, lopsided and unfair, does describe everything about Scientology. Old Frizz, this does sound promising. Northern Girl, the only problem is the church aspect, though. No, so many stupid protections under the guise of religion. Sharona, hopefully other circuit court of appeals, particularly the 9th and the 11th, find persuasive authority and rule the same way. Nerman, haven't seen you in a while, Nerman. Religious exemption in 1993 equals organized crime. Northern Girl, real world law needs to be brought into the Scientology world, especially when it comes to CSA. Yes. Life on the streets. Religion and the church is not about God. It's about business in America. It is all about the money. Nerman, on the verge of exposing CST cult. Old Frizz, always appreciate your optimism, Aaron. Thank you, Old Frizz. Northern Girl, I just hate the lack of common sense when it comes to some of these laws. Allison Gannis, people in Scientology all their lives don't even know about all Scientology, i.e. the OT levels. How would a court be expected to? True. Eddie Congress, Scientology will never lose a tax-exempt status because real religion will tell politicians. If they come after Scientology, they'll come after the Catholic Church. It really depends. There's definitely strong arguments to be made on both sides of this. It's like if I put myself in the shoes of established mainstream American religion, I feel like I'd be like, those guys don't sit with us. Those guys can't sit with us. Like, I mean, Scientology is literally a pay for play scheme. It's an organization that doesn't even believe in a supreme being, doesn't believe in God, and you have to pay for everything you do in Scientology. It couldn't be more different than normal organized religion. And I say that I'm not a pro-religion guy. Like, I'm also not an anti-religion guy, but I'm not religious in any sense of the word. And here's what I will say. Scientology is certainly counting on what you're saying, that the religious powers that be in America would rather fight for Scientology's rights on the assumption that if Scientology falls, they will be next. They would likely rather go that direction than to say, you know, in order to protect what we have, we should be able to distinguish between us and other things that just pretend to be like us. And the optimistic part of me always considers how easy it would be for the religious powers that be to be like, do you know the real way to strengthen your position? Don't let everyone get on your bus. That's the real way to strengthen your position. Be like, no. This is where we draw the line. Those guys aren't with us. But what do I know, guys? I grew up in a cult. Old Frizz, pretty amazing story, really. The IRS thing, almost admirable if it wasn't for such evil reasons. Absolutely. Guys, I know it's already late, but I'm thinking of doing another video tonight. I won't make George stay up, but stay tuned. If you guys want more SPTV Late Night Edition, hang in there. There might be more coming. Thanks for hanging out with me, and I might see you soon. Otherwise, I'll see you tomorrow. All right, good night.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe right here. Bye.